Tantor Audio, a division of Recorded Books, presents The American Judicial System, a very short introduction by Charles L. Zelden, narrated by Tristan Morris. Preface: The Contours of the American Judicial System. The American judicial system is important. Courts can have as great an impact on most Americans' lives as, or in some instances greater than, that of the President or Congress, a governor, or a state legislature. This has been so since the founding of the American constitutional system in 1789. Even so, most Americans, let alone non-Americans, do not know about, much less understand, the workings of these courts. The ignorance is not simply the result of apathy or lack of interest. The American judicial system is complicated, confusing, and frequently opaque in its operations and motivations. It is often hard to understand how courts work and what effects they have, even when people want to comprehend. Unlike most Western nations, the United States does not have a single unified judicial system. Rather, it has 51 separate judicial systems, one for each state, and one for the nation. The federal court system, which itself includes two categories of courts, one organized under the authority of Article 3 of the U.S. Constitution, known as constitutional or Article 3 courts, and the other organized solely under the lawmaking power of Congress, known as legislative or Article 1 courts. Each of these 51 judicial systems has features unique to it alone, yet each shares common elements with the others, and all of them are interrelated in various ways, so that we can speak in the singular of an American judicial system. Still, the American judicial system, made up of these 51 court systems, is complex and multifaceted. This book's purpose is to introduce this complex mix of local, state, and federal courts that we call the American judicial system. It focuses on the structures, functions, workloads, and powers of American courts, the politics and laws that shape these courts' judicial functions and their exercise of their powers, and the people who constitute that system's backbone. This book's goal is to explain in simple terms how this complex and diverse mix of people, institutions, and rules combines to give the United States a workable legal system that meets, or in some cases does not meet, the needs of the American people for law, order, justice, and dispute resolution. Underlying this discussion will be a simple question. How can the United States have 51 separate legal systems and still be accurately described as having a single judicial system? After all, the differences between the various state court systems and between them and their federal counterparts are notable and extensive. Each court system ostensibly enforces a different set of substantive laws and applies its own legal rules and procedures, although federal courts can and do enforce state laws and vice versa. The specific court structures, number, distribution, and jurisdictions vary widely. The personnel making up the court systems, in particular the judges who lead these courts, also vary as to background, method of selection, and terms of service. Nearly every generalization that we make about the American judicial system has an exception. Somewhere, some state or federal court does things differently, separating itself from all the rest. Yet despite such diversity, in the end, there are enough similarities to outweigh the differences. Viewed together, the state and federal judicial systems exhibit several shared themes and functional parallels in their principal structures, tasks, methods, and purposes. Viewed more by what they do than by how they do it, American courts are in fact reasonably similar. This correspondence should not eclipse the genuine and extensive differences that do exist, or the impacts that different substantive laws and procedural rules have on people's lives. Nonetheless, these differences are more surface than core. A first commonality is that the units composing each judicial system are courts of law, whereas the specific structures in which these institutions operate vary, and the rules they enforce differ. Their overall purposes and functions remain the same: the settling of disputes, public and private, effectuating transactions agreed to by parties, acting as guardians of private rights and liberties, enforcing societal norms and rules, creating expectations of proper legal and social behaviors, and making and enforcing public policy choices. Similarly, the functional structures of courts, how they are organized, the types of personnel they employ, the jurisdictional divisions sorting courts into different types and categories, generally follow similar patterns across the nation. A second commonality arises from the limits within which all American courts operate. John Adams, the second President of the United States, declared in his draft of the Declaration of Rights of the Massachusetts Constitution of 1780 that ours is a government of laws and not of men. This truism applies especially to the judicial system. The powers, functions, and applications of courts of law are by their very nature bound by the rule of law itself. Specific details may vary from court system to court system, but all courts are limited by the laws as to their powers, areas of focus, and methods of operation. A third commonality has to do with the underlying sources of judicial authority for each of these 51 court systems. Though the specifics vary, all courts are the creations of constitutional imperatives and directives. Written constitutions in the 50 states and one constitution for the nation as a whole set out in varying levels of detail the general outlines of the judicial system, dictating forms, ordaining functions, setting jurisdictions, outlining powers, and delineating the methods by which judges and other court personnel are chosen. From this foundation rise substantive laws set by the legislative branch that the courts may consider. Courts also promulgate procedural and evidentiary rules by which courts operate. Last, all courts operate under a set of professional standards and traditions of legal practice, shaping their day-to-day operations. A fourth commonality has to do with judicial impact. Courts affect the lives of millions of Americans. This impact can be direct, as with the roughly 100+ million Americans who find themselves personally interacting with some form of court services each year, or indirect, based on the policy implications of cases usually decided by appellate courts. In either case, courts provide services necessary to the smooth running of the American legal, economic, political, and social systems. Last, we must account for the political nature of courts. Courts interact with the other branches of government that are political in nature. Courts are consequently affected by political trends, and conversely, their rulings and actions will affect politics and policy-making. While these interactions may produce varying results, courts are by nature political players whose actions are integral to the working of our nation's governing process and institutions. Taken as a whole, the resulting picture of the American judicial system depicts a complicated, multifaceted, interconnected, contested, and important set of institutions working both separately and together to provide law, order, justice, and dispute resolution. The picture, at times, is not pretty. In many places, the results of the American judicial system's efforts fall short of its fundamental aspirations. In other instances, this patchwork of state and federal courts does its job efficiently and effectively, serving the American people well. Yet successful or not, efficient or not, the American judicial system is a significant force in shaping people's everyday lives. Given this fact, understanding the workings and impacts of the American judicial system is essential. Chapter 1. Structures and Jurisdictions. Courts are the foundation of the American judicial system. They are the means by which government helps to resolve disputes between ordinary citizens, between persons and the government, between branches of governments, and between states. Courts uphold social norms. They oversee the uniform application of the laws and rules necessary to the smooth operation of American life. Granted, government also has administrative agencies, which provide administrative means to resolve disputes arising under the rules these agencies make and enforce. But for most Americans, disputes arising under the law that apply most directly to their daily lives are adjudicated, resolved, or settled in and by courts. The American judicial system contains many categories of courts. Some courts focus on a single field of law or type of controversy. Others are open to a wide range of legal conflicts. Some are limited by geography in terms of what cases they can hear and what impact their rulings will have. Other courts have statewide or nationwide caseloads, and their rulings have statewide or nationwide impact. Some focus on the details of disputes brought before them, providing specific remedies to the litigants in a case. Others are more concerned with the scope, meaning, and proper use of the law. Courts also come in many shapes and sizes. Some courts are administrative in nature, providing authoritative notice, judicial guidance, and official validation to matters largely settled outside the courtroom by the litigants themselves. Others are trial courts, acting as forums in which to resolve disputes, public and private. Some courts serve an enforcement role, upholding public standards and norms, or enforcing obligations and effectuate transactions, while still other courts hear appeals from trial courts and thus seek to provide uniformity in the application of the law. Confusingly, many courts combine a number of these functions, while others are limited to one function and only that one function. Even more perplexing, the mix of judicial functions served by specific courts varies by state. In some states, judicial enforcement and dispute resolution might be divided between different courts, while in others these powers or functions are combined into a single court. Adding to the confusion, different judicial systems adopt different naming patterns. Each state is free to name its courts however it wishes. There are some typical naming protocols, but variations exist. For instance, most states name their top court the court from which there is no appeal, except in specific circumstances to the U.S. Supreme Court, the Supreme Court. In New York, however, the top court is the New York Court of Appeals, whereas the New York Supreme Court is a statewide mix of trial and appellate-level courts, getting its name from the idea that those courts are the state's highest-ranking trial courts, superior to city courts and county courts. Texas splits its top court into the Texas Supreme Court, which hears only civil cases, and the Texas Court of Criminal Appeals, which handles criminal matters. In Florida, trial courts go by the name circuit, and intermediate appellate courts have the name district. By contrast, in the federal system, and in states such as Arkansas and Louisiana, the trial courts are district courts, and the appellate courts are denoted courts for a specific circuit. Other common names for trial courts include superior, county, state, trial, municipal, and court of common pleas. Most intermediate appellate courts go by circuit or district, or simply appeals court. Given the wide variations in naming patterns, it is simpler and more efficient when identifying courts across state and federal jurisdictional lines to focus on the functions a court serves. When dealing with a single court system, however, it is generally best to simply accept the naming pattern used by that court system. Categorizing courts by size, focus, and impact. Sorted by function and jurisdiction, we can identify 4 primary levels or types of courts in the American judicial system: trial courts of limited or specific jurisdiction, trial courts of general jurisdiction, intermediate appellate courts, and appellate courts of last resort. Also present is a 5th category of highly specialized courts that sit out of the normal flow of litigation from lowest court to highest. Viewed collectively, these courts are organized in a rough pyramid shape as to function and the number of cases that they process. At the lowest or foundational level of the judicial pyramid are trial courts of specific or limited jurisdiction. Such courts are limited by law to adjudicating cases of a single legal topic or focus. In many cases, these courts are further limited to a specific geographic territory, such as a city or county. 43 states have single-topic courts of this sort. The most common types of state courts of limited jurisdiction include traffic courts, small claims courts, city and municipal courts, judicial bureaus, and justice of the peace courts. Such courts of limited jurisdiction generally do not hold formal trials with juries, nor, in fact, do they oversee many trials at all. What ties them to other trial courts is that their jobs focus on the enforcement of social norms, procedures, and rules. These tasks are common to all forms of trial courts, but their methods of achieving these shared goals are different. Given their focus on a single topic, trial courts of limited jurisdiction generally compress the legal process into an efficient routine aimed at processing large numbers of cases quickly. Take, for example, traffic courts. Most traffic court cases result in guilty pleas. Many defendants do not even bother to attend court, but plead guilty and mail in payment for their fines before their first court date. Most of those who do attend still plead guilty. Their strategy is to appear in the hope that the judge will reduce their fines compared to what they would have paid by mail. Of those pleading not guilty, most do so in the hope that the arresting officer does not appear in court. When the officer does not appear, a common occurrence, traffic judges normally dismiss the case. When trials do occur, traffic court trials are typically bench trials, decided by the judge sitting alone. Most are abbreviated affairs in which testimony is heard only from the arresting officer and the defendant, quickly followed by a ruling by the judge. In consequence, traffic judges generally can process many dozens of cases in a single day. Trial courts of limited jurisdiction attend to most cases filed in the United States, which explains their focused structures, their emphasis on routine or recurring matters, and their tendency to process cases quickly. In 2013, for instance, limited-tier state courts handled over 62 million cases, 66% of all incoming trial court caseloads. Over half, in turn, were traffic violations, approximately 39 million cases in total. A 2017 study of 20 states found a similar pattern, as traffic violations totaled 3 of 4 state cases filed. In some states, minor criminal matters, misdemeanors in which the maximum punishment is no more than a year in jail and/or a fine of no more than $1,000, are also delegated to trial courts of limited jurisdiction. In 2013, criminal courts of limited jurisdiction processed 13.6 million criminal cases in those states using such courts. 4 years later, the total number of criminal cases had fallen to around 10 million, but the 3.5 to 1 ratio between misdemeanor and felony cases remained the same. In the federal system, bankruptcy and magistrate courts function as trial courts of specific jurisdiction. Both are deemed subunits of the federal district courts. Each is tasked with specific subject matter jurisdictions: bankruptcy courts for bankruptcy and related matters, and magistrate courts for preliminary and administrative subjects, such as setting bail or overseeing the first appearances of a criminal defendant. In both cases, the district courts hold formal authority over these matters, but refer them to the lesser courts for administrative convenience and expediency. The next higher level of the judicial pyramid contains trial courts of general jurisdiction, what most people think of as trial courts. Courts of general jurisdiction hear a wide array of cases, civil and criminal. It is at this level that jury trials occur, and that the facts of a case are judicially determined and effectively set for all further proceedings in that case. Moreover, it is here that litigants have their best chance of having their own needs and wants met. The higher a litigant goes on the judicial pyramid, the more they will find the court's focus shifting from the specific facts of their case to the proper reach of the applicable law. The result is a somewhat inevitable shift from fact-centered to legal-centered outcomes. Like courts of lesser jurisdiction, trial courts of general jurisdiction have various naming and organizational patterns. Most states and the federal system designate these courts as either district or circuit courts. However, some states identify trial courts of general jurisdiction as superior courts or courts of common pleas. 4 states, Delaware, Mississippi, New Jersey, and Tennessee, break up their courts of general jurisdiction into 2 divisions, each with its own rules of procedure and separate judges. One kind hears matters of law, generally cases involving property and the resolving of disputes about property or breaches of contract, with the result being the awarding of money damages, and the other of equity, cases that involve a civil wrong that needs righting, with the court issuing a judicial order compelling one party to do something or not to do something, rather than paying monetary damages. The remaining 46 states and the federal system combine these 2 categories of legal powers in a single court. Though technically all courts of general jurisdiction have the power to hear civil or criminal cases, most states designate some trial courts as criminal courts and others as civil. This designation, however, exists primarily for administrative reasons. In most states, judges in courts of general jurisdiction are permitted to hear either category of dispute. At the federal level, the district courts preside over both civil and criminal cases and exercise both law and equity jurisdiction. As with courts of lesser jurisdiction, most civil and criminal cases in courts of general jurisdiction are filed in the state courts rather than federal courts. Though state courts of general jurisdiction only processed around 20% of all state cases filed in 2017, the total number of cases managed by these courts still topped 15 million. In comparison, civil and criminal cases filed in the U.S. district courts that year totaled only 367,937. Moreover, cases filed do not necessarily equate with trials held. Most cases brought in courts of general jurisdiction never go to trial. Many result in default judgments, summary judgments, or judgments on the pleadings, judgments in which the judge rules based on the papers of the case without holding a trial, because of procedural, legal, or evidentiary failings on the part of one or both litigants, or because one side failed to show up to argue their side of the case. More commonly, large numbers of cases are settled by the litigants before trial. In fact, the closer a trial is to starting, the more likely it is the dispute will be settled. A significant number of other cases are redirected to court-mandated mediation and/or arbitration. The result is that a limited number of trials are argued before a judge. At the federal level, of the roughly 307,000 cases filed with the U.S. District Courts in 2019, only 2,322 went to trial. Colorado held only 1,700 trials, of a total of 216,735 cases terminated in 2014. In Texas, trials, bench or jury, totaled only 14.5% of all cases terminated in 2015. In addition to hearing original cases filed directly with the court, trial courts of general jurisdiction are also typically designated to hear appeals from trial courts of limited jurisdiction. In these instances, the general jurisdiction court does not serve as an appellate court reviewing the application of law by the lower court, but hears the matter from the lower court de novo, literally from the new, retrying the case without reference to the prior proceedings of the court of limited jurisdiction. Most major court cases, civil or criminal, start and end in a trial court of general jurisdiction, as litigants generally accept their case's outcomes, won or lost, settled or dismissed. A significant percentage, however, continue to the appellate stage of litigation. Appellate courts review the decisions of lower courts. Their job is to determine if the proceedings below were properly conducted. More specifically, they review lower court decisions to determine if the law, procedural and substantive, was correctly applied. Hence, appellate courts primarily serve functions defining and enforcing laws. It is their job to determine what the law is and is not, and to see that the procedural and substantive laws used by lower courts are uniformly applied and enforced. All states and the federal judicial systems have appellate courts. In 10 states with lower population and litigation levels, the appellate courts of last resort serve as the only appellate court. All appeals go to this court for their one and only chance of review. The remaining 40 states in the federal system use one or more categories of intermediate appellate courts between the trial courts and the court of last resort. Intermediate appellate courts exist to filter the appellate process. In most states and the federal system, the losing side in a trial has the privilege to demand appellate review, as outlined by statute or constitutional provisions, what is called appeal by right. Appellate courts must take up these appeals and review the records from the lower court to ensure that no mistakes of substantive law or legal process occurred at trial. In states with large populations, these mandatory reviews can number in the thousands each year, hundreds of thousands nationwide. Most appeals by right ultimately prove to be without merit. That is, in most cases the appellate court finds that the trial judge did not misapply the law in determining the outcome of a case. Still, it takes time to conduct these reviews to ensure that no mistakes were made. Moreover, the pendency of an appeal often creates a new opportunity for the parties to reach a settlement. Unlike appellate courts of last resort, which generally sit en banc, as a single group, to hear cases, intermediate appellate courts generally break up into panels of 3 randomly selected judges who are assigned to review appeals. Given that most states have multiple intermediate appellate-level courts, there are generally more intermediate appellate court judges than those sitting in the court of last resort. Sitting in panels of just 3, intermediate appellate courts, with their greater number of judges, therefore can hear many more cases. The result, despite the substantial number of appeals by right filed with such courts every year, is that these courts successfully process most appeals filed annually, in many years clearing out 100% of appeals before them. In most appeals, intermediate appellate courts, despite their designation as intermediate, are the final courts to review a case. In 2017, state intermediate appeals courts heard 70% of all state appeals filed nationwide, whereas state supreme courts only heard 30%. And this number includes cases from those 10 states that do not employ intermediate courts of appeals. Thus, 7 of 10 appeals started and most ended in the intermediate court of appeals. The gap is even greater at the federal level. Between April 1, 2018 and March 31, 2019, the 11 regional U.S. Circuit Courts of Appeals heard 47,977 cases. The U.S. Supreme Court, in contrast, currently accepts no more than 80 cases a year, and that number includes appeals from state Supreme Courts. All of this means that appellate courts of last resort, which sit at the top of the judicial pyramid, acquire their importance not by volume of cases decided, but rather by their exclusivity. Unlike intermediate appellate courts, Supreme Courts of last resort generally get to choose which cases they hear. This power allows them to select cases that raise matters of serious legal, constitutional, or public concern. Their focus, in other words, is less on the individual case before them, and more on the wider legal and constitutional issues raised by the case. Courts of last resort thus not only perform rule definition and error enforcement roles in common with intermediate courts of appeals, but also serve an important policy-making function. It is in providing this last function that courts of last resort have their greatest impact. Finally, there are specialized courts. These are technically courts of limited jurisdiction, in that they focus on a single topic or issue of law. What separates them is a combination of their focus and their existence outside the normal hierarchy of the judicial pyramid. Most specialized courts concentrate on highly technical matters, requiring specific expertise to process their cases, and often hear appeals of matters initially litigated outside the normal court hierarchy, such as reviews of the actions of executive agencies or the military. At the state level, specialized courts include family law courts, juvenile courts, probate courts, and drug courts. Unlike high-volume courts, such as traffic and small claims courts, these courts put less emphasis on processing large numbers of cases quickly, and more on providing specialized services based on expertise in the subject matter. Drug courts, for instance, emphasize the ongoing supervision of those under its authority with the objective of helping these defendants overcome their addictions, rather than simply adjudging guilt and imposing sanctions. Probate courts administer the proper distribution of the assets of someone who has died, determining the distribution of assets for those who die intestate, without a will, as well as supervising an executor's overseeing of an estate. Specialized courts are prominent in the federal judicial system. The typical federal judicial pyramid consists of 3 levels of Article III, or constitutional courts, district courts, trial courts, circuit courts, intermediate appellate courts, and the U.S. Supreme Court, the court of last resort. Yet there are other federal courts that sit parallel with these courts. Most are organized under Congress's lawmaking powers, as set out in Article I of the U.S. Constitution. These legislative courts, as they are called, exist to review large numbers of administrative decisions made by executive branch agencies and the U.S. military, or to adjudicate large numbers of specialized cases raising technical issues such as those having to do with immigration, patent.
Sample complete. Ready to continue?